copies for those, yours?
Mm-hmm.
Okay, just making sure. I'm gonna go talk to somebody real quick. I'll be right back.
Okay. Who will be here?
And it's metal, but unfortunately, unfortunately not. It's like I was the first not
She is not. I am covering. Jessica, Christine, me, and two girls.
You're Sarah,
Yes.
and Jessica was her.
Yes,
Okay, I'm going for some.
yeah, you, I guess you objected to his one.
Burglary, yes, a qualifying offense. If you thought you should try to work.
She would come from, no.
Oh,
I don't think she necessarily was responsible.
okay, let me look at Sarah's.
Yeah, would you check the minutes?
Yeah, I will.
She's tired.
Yeah, that's what's happening, is we've got people in charge.
Structure.
Jessica was,
And there's another person in the structure that's not in her two names. That's why they, that's why. Because it's second found. And that's what, that's the only thing, yeah. I never knew that. So because
How are you?
because I was wondering.
You just figure out what you need to do.
yeah.
Oscar Villalobos for Otra Personas for Steve Medina. Never know. That's a new one. It's kind of harsh, but
Hey,
that's what it is.
so on this Rivers and
Yeah.
Jessica, you know, she was Sarah, told me to go forward.
I think that has to have been the recent change, because I never remember seeing
Yeah.
occupied structure,
I-
occupied conveyance.
Yeah. Everybody good?
Yeah, just call. Okay, well,
Judge Brown.
she was-
Judge is en route to the courtroom, he was on his
Okay, I'll
cell
text
phone,
her.
we passed the last
It's
week.
fine, because that's emails on.
It's a good question. I thought it changed. But it's, you sure?
Well, it was just the motion and the, that's all I know. Okay. Okay,
bid this afternoon? What you got one?
I don't have anything going this afternoon.
Okay, I'm just a couple of hearings, just a sentence, I just want to make sure.
Braxton is not going, that was
Okay,
going to
thank
be his one here.
That's what I shared.
I appreciate you
Just
asking.
this persona.
Wait, this is your only case on this afternoon?
Yeah.
Nice. I guess I only have
Six.
two.
How many unrepresented do you have?
What did you say?
How many unrepresented do you have?
Well, I don't know, that is a separate question.
Always got,
I don't have them yet.
gotta have that, gotta know what you
That's why
might
I always
get.
stick around.
Well, that's why you're the leader of the division.
Far from
All the
it.
honors to which that entails.
I didn't even know that there was a such thing as a burglary of an occupied structure as a secondary felony till you showed me.
Tell you what, there's.
All rise, please. Board is now in session. The Honorable Judge Karen Campbell presiding. Please be seated.
Okay, so we're here on the arraignment portion of the docket here today. The arraignment is basically the first hearing after an arrest. There are a number of people that are here in the courtroom that are here for arraignment, but who do not have an attorney. So, as you probably know, if you don't, I'll tell you that you have a constitutional right to always have an attorney. If you cannot afford one, one will be provided to you. So, when you come forward, because the purpose of today's hearing is to make a plea only, I'm going to ask you first whether you want to have an attorney. And if you accept that, we'll enter a not guilty plea so you can have the time before we come back to discuss the different options with the attorney. The state also sometimes, in certain circumstances, may be willing to make an offer for a plea. If they do, you can consider it, but in any case, you always have the right to talk to your attorney first. So I'm just kind of telling you that so I don't have to repeat myself and tell each individual that comes forward. So, I think we'll go ahead and begin with folks that don't have an attorney that are out of custody. So, is Kyrese Childers here? And come on up to the podium. I didn't tell you that. Just come right up to the podium. Would the state announce?
Yes, Your Honor, that's 24 CF 1960.
Okay. So, as I said, Mr. Childers, you do have the right to have an attorney. If you cannot afford one, one will be appointed. You want me to appoint you a public defender, or are you going to hire a private attorney?
Is one required?
One is not required, but suggested. These are can be complicated things. I know what you've been charged with is a felony, potential 5 years prison sentence. So, I always suggest people have an attorney. If you come dealing with state with all their attorneys and whatnot, you're always at a disadvantage, but it's up to you. No, you're not forced to have an attorney.
Well, if you're strongly suggesting it, then I might as well.
I would say that I'm strongly suggesting it.
Yes, sir.
Okay, so I'm going to appoint the public defender, and as I said, I'm going to enter a not guilty plea on your behalf, and we'll come back. Are we setting them in December or October? So we'll come back on October 14th, give you a chance to meet with your attorney.
And Your Honor, the state might be able to work out a misdemeanor probation offer with the defendant if he has the ability to pay the victim back the restitution. So that's something that he and Ms. Farkas need to meet about. And then Ms. Farkas can communicate with me about whether that's something we can work out.
Okay, very good. And I didn't say what the attorney is telling her client is that you gotta, if you have an attorney appointed, you gotta fill out the financial, little brief, small financial affidavit to make sure you qualify. So if you make too much money, they can't appoint you an attorney. Okay? So is Jakara Clark here? Thank you.
Yes, sir.
So,
Good afternoon.
good afternoon. This is case number 24 CF 1911. Again, ma'am, you do have the right to have an attorney. So my first question is, do you wish me to appoint an attorney for you, or are you going to hire a private attorney?
I was looking to hire one, but I need some time because I just got out and just started working. So I was interested in hiring one. But
Okay.
I know it's gonna take me a little time though.
How long?
I
So
guess
we're
it's
gonna
just
be
depending on-
coming back on October, which is a little more than a month, October 16th, October 14th, excuse me. Correct? Madam Clerk? So you're currently scheduled to come back on pretrial on October 14th. I can enter a not guilty plea in your behalf, which preserves your rights. And you think you can get an attorney during that period? That's a month?
Could I possibly get a little more time than that?
Well, let's leave it for 10/14. You can give me an update on whether or not you've been able to get an attorney.
Okay, so when I come on the 14th, I can update you.
You can
Yes, sir.
let us know what's going on,
Okay.
but don't want to wait too long because these things drag out anyway, believe me. Okay?
Yes, sir.
Okay.
All right, thank you so much.
Thank you very much.
All right.
Megan Cooper? Megan Cooper.
Your Honor, I'm looking up the notice right now.
Any chance? Okay. Mr. Heath was appointed and filed not guilty, so we'll come back on 10/14. Continue until 10/14. Joseph Francis. Madam, would the state announce?
Yes, Your Honor, this is 24 CF 1887. This is Ms. Jardina's case that I am covering.
Okay.
And Ms. Jardina's offer to the defendant in this case is adjudicate 30 days Okaloosa County Jail to $515 in court costs. I don't know.
So, Mr. Francis, you do have a right to have an attorney appointed because they're offering you a jail incarcerative sentence. You might want to talk to your attorney first. You wish to have an attorney appointed?
Yes.
Okay, so the court will appoint the public defender. I'm going to enter a not guilty plea to protect your rights. We'll come back on October 14th in the interim. Meet up with your attorney. You can look at your different options, okay?
All right.
Santos Garcia Ramirez.
Your Honor, that's 24 CF 1919.
Okay, that's my question. No.
Good afternoon, Your Honor.
Good afternoon. So, this is case number 24 CF 1919. You've been charged with felony battery. So, you do have the right to have an attorney. And if you cannot afford one, a private attorney, one will be appointed for you. Do you wish to have an attorney appointed?
I would like an assigned attorney, Your Honor.
Okay, the court will appoint the public defender, and the court's going to enter a not guilty plea on your behalf. That preserves your rights and allows you to meet with your attorney to look at your different options. So before you leave, you got to fill out the financial affidavit, but get a card that has the information so you can make an appointment with your attorney before you come back. We'll come back on October 14th at 9 a.m. Okay. Any questions?
No, Your Honor, I don't have any.
Okay, thank
14
you.
de octubre a las 9 de la mañana tiene que llenar esta.
Matthew Henry? Would the state announce?
Yes, Your Honor, this is 24 CF 1959. This is
Right.
also Ms. Jardina's case.
Mr. Henry, as I said, you do have a right to have an attorney. Wish to have an attorney appointed or hire private counsel?
Hire private.
Okay. So you wish to enter a not guilty plea here today, I assume?
Correct, Your Honor.
Okay. Court will enter a not guilty plea. We'll come back on October 14th at 9 a.m. Please make sure to retain your attorney in the interim and meet up with them so when you come back,
All right.
you'll
And
be
Your
able to have an
Honor,
attorney.
Ms. Jardina's offer to withhold on all counts in these cases and place Mr. Henry on 24 months of probation will remain open so that he can speak with a lawyer.
You can maybe pass that on to your lawyer. when you-
I will. Thank you, Your Honor.
Okay.
Just one more.
Okay. That's all the out of custody. Ms. Farkas, do you have any out of custody cases?
Yes, I have one. He stepped out to smoke a cigarette with his father. so he
Mr.
will be back.
Gates?
Yes, Your Honor, I have 2 out of custody I can handle.
Okay.
If I can call Caitlin Jacqueline, it's Gia,
But it's pronounced differently than that, Your Honor.
How are you pronouncing that, counsel?
Jeff Leon.
Jeff Leon.
Jeff Leon, okay, very good.
At this time, Your Honor, we're going to enter a not guilty plea, and it's already scheduled for October the 14th.
Very good. We'll enter a not guilty plea on your behalf. We'll continue this matter until October 14th at 9 a.m.
Yes, sir. Thank you.
Okay, information has not been filed, so
It's with Ms. Bosley, Your Honor, so it sometimes takes her a little bit longer to get those filed.
do we need to?
I'll go ahead and waive arraignment for Ms. Leon and have her scheduled for October the 14th.
Okay, so we'll still keep her on for October 14th. We're not going to enter a plea, so you need to,
Yes, Your
you can do that in writing. Okay, thank you very much.
Next I've got is Corey Groves. Mr. Groves is before the court 24 CF 1869. This time we'll enter a not guilty plea on his behalf. It is already scheduled for October the 14th.
Very good. We'll enter a not guilty plea on behalf of your client. We'll continue this matter until October 14th at 9 a.m.
Yes, sir.
Meet up with you, stay in touch with your attorney.
Yes, sir.
Mr. Groves? Have a seat. They got it.
No, show it to him.
Yeah, so I just wanted to make sure before we.
Yeah, I can show them when I ring, so.
That's a direct fellow. He's already been served and arrested and got the first appearance of on that.
I just wanted to make sure.
Your
Better
Honor,
safe than sorry.
my out of custody client, Sean Seifert, is here.
Okay,
2024 CF 1616, Cypret, CYPRET.
okay, very good.
We So Mr. Cypriot had an arraignment date on August 15th. A capias was issued. We had it withdrawn. There was confusion about the date, so he was put on for this new arraignment date. So we'd like to enter a plea of not guilty. And I think he's already scheduled for the 10/14 pretrial date.
Is that correct?
Yep.
So we'll continue it until 10:14 at 9 AM.
Thank you.
Judge, I'll do that.
Okay. I can't read it, but you can.
Your Honor, I'm not sure if there is a bond set in the warrant. Did the, let me see.
We can try and pull it up if you have a case number.
They've got a piece of paper about it.
Wow, I'm old too. 2024, nope. I don't know that I can read that. 2256?
Have any other case? It's a new house.
Yeah, I just,
Case,
I don't see anything about a bond being requested by the judge who signed the warrant. I'm not sure if I can make any sort of argument for a bond for first appearance tomorrow morning.
I don't know, what do we have at this point?
It's a, I think it's fraud.
Yeah.
What is it?
Fraud from January of 2024?
It's ask the state
Yeah, yeah.
if we can do a signature bond.
So, can I show this to the state? Sorry. Yeah, I apologize. I just wanted to try to address the bond with the state before first appearances are made. Yeah. Okay. We could pass this. He's not gonna go anywhere if he could sit in the courtroom, so I can speak with the
Okay.
state about it.
That's fine.
Okay, thank you so much, Your Honor. Oh, he's good.
I just make sure it's filled out correctly.
Mr. Medina, do you have any item?
I have one out of custody, I will need the interpreter, Your Honor, whenever Ms. Teresa can, okay, can we get, Coskin Villalobos? I don't know if, the interpreter's been sworn in, Your Honor, but.
We'll swear her in. Would you swear this over?
Please state your full name. Teresa Iribarren. Do you agree to accurately translate from English to Spanish and from Spanish to English to match before the court and all of that? I do.
And what is the case number,
Your
Mr.
Honor, this
Medina?
is 24 CF 1973, Jesus R. Boscan Villalobos.
Very good.
Your Honor, at this time, Mr. Boscan Villalobos will enter a not guilty plea, and he is set for October 14. And he is going to fill out the clerk's application and turn it in on the first floor. And I've given him my card with my assistant's name on it. He's going to call her next week and set an appointment.
Very good. The court will enter a not guilty plea on defendant's behalf, and will continue this matter until October 14th at 9 a.m.
Thank you, Your Honor.
I also haven't, no, that's good for this. Ms. Teresa?
Yes,
Do
sir.
we, I've got an add-on here that shows no attorney, Aru Esparzo.
I do too, Your Honor.
Is
I'm going
he
to
here?
make an announcement. Arrue Esparza. He is present and approaching, Your Honor.
Very good.
He does not need an interpreter, Your Honor.
Okay, very good, thank you. Would the state please announce?
Yes, Your Honor, I am looking for that case.
24 CF 1769, it's not on the docket. Possession of a controlled substance, DUI. So, Mr. Esparza, you do have a right to have an attorney. Do you wish to have an attorney appointed, or are you going to hire a private attorney?
Have one appointed.
Okay. The court will appoint the public defender, and the court will enter a not guilty plea in your behalf. That just protects your rights, status quo. And you can, we'll come back on October 14th at 9 a.m.
I have a question.
Okay?
So I have a paper that says I'm supposed to come back on the 14th of October already.
Correct.
I live in Louisiana. I had a trouble getting here. I had a friend bring me.
So, Your Honor, I'm just explaining that he can make an appointment with the public defender, and we'll discuss how to handle his court appearance on October 14th.
Yeah, and he might be able to get, he's got some things, he's got some
Okay.
different procedures he can help you to, so you don't have to come over.
Does he have a completed public defender application? Okay, thank you. Right?
That's it?
Yes, so just
Okay.
call Karen next week.
Okay. Appreciate it.
Okay, thank you.
And we'll talk about it. Thank you. Sir.
So, is anybody else out in the gallery that believes they have a court hearing today? You do?
Your Honor, yeah, we also have a hearing to perfect a subpoena for the state of Indiana with Mr. Hausman. The court.
Okay, well, let's try and get the other defendants out of here first.
He received a subpoena, he's not actually on the docket.
Yeah, he's
Okay,
not on the docket.
okay. Anybody else that thinks they have a court hearing this afternoon? Okay, very good. So now, what's your question now? You
On
can
Mr.
now.
Hausman?
Yeah,
So, Your Honor, I don't know if you remember, but the state of Indiana has a DUI homicide, a DUI manslaughter that they needed a subpoena perfected for. We did that before their trial got continued, and so they have issued we have issued another subpoena for Mr. Hausman to be here so that the court can enter a verbal order for asking for him to be served by State Attorney's Office Investigator Jeremy Peden, and asking the defendant if he will accept that subpoena from Investigator Peden. If he does that, Investigator Peden is ready to serve him at our office as soon as the court.
okay. Come on up, sir. So you heard that, state attorney, they're basically asking, are you willing to accept the subpoena from
Yes, Your Honor.
Louisiana?
Yes, Your Honor. And I was in Atlanta when they canceled, so I mean.
Okay. So what is your who's going to serve him?
Is that Jeremy Peden from
You need to give him directions to your office?
Yes, Your Honor, I believe he's been there before, he's been served with a subpoena by Investigator Peden.
So should he go over there from here?
Yes, Your Honor.
And your server is waiting for him?
Yes, Your Honor.
Okay, anything else we need to do?
Is it the court's verbal order that the state attorney's office can serve him with the state of Indiana subpoena?
So ordered.
Thank you, Your Honor.
Okay, thank you, sir.
Thank you, Your Honor.
Okay. Let's do our in custody.
Thank you. Did you call me? Did you need me, Judge? I don't mind waiting if you want, but.
Just give me a few more minutes and we'll be through with it.
I was outside when you called.
That's all right. No. I didn't call it yet.
Oh, okay, thank you.
Ms. Farkas, do you have any in custody?
Yes, Julius Cone, C-O-N-E.
Yeah, you can bring in whoever you want. We'll deal with it.
She also needs to get the interpreter so she can.
Do we need the interpreter? We need the interpreter on this one?
On only one inmate,
Okay,
and then she's needed downstairs.
okay. Come on, we'll do that first, Miss Teresa. Which
Verona
Barona Espinol.
Barone, Buenas, mirando al juez, por favor.
Okay. So this is case number 24 CF 1928. It's burglary of an unarmed, unoccupied dwelling. Mr. Espinol, you do have the right to have an attorney represent you. If you cannot afford one, one will be appointed. So my first question is, do you wish to have an attorney appointed?
Yes.
Okay. The court will appoint the public defender. The court's going to enter a not guilty plea on your behalf. That just status quo protects your rights. And we'll continue this matter until October 16th in order to allow you to meet with your attorney before and figure out what your options are. And that little piece of paper they handed you is a form that you need to fill out just to verify that you don't have enough income so you can have an attorney appointed. Okay. Any questions, sir?
No, sir.
I'm just looking at
Your Honor.
I just need your rights.
Your Honor.
It's,
I wanted to make sure he knows that line is sitting at 30 days of jail or remain open.
Solo quería dejarle saber que la...
tell Mr. Medina too.
Mr. Medina and Mr. Espinal, the state's misdemeanor trespass and 30 days Okaloosa County Jail offer will remain open so that he can speak to Mr. Medina about
So
it.
you're offering a misdemeanor trespass?
Yes. In 30 days Okaloosa County
Your
Jail.
Honor, given the nature of this, I don't know what his family situation is. Could he just be set aside and I'll go talk to him?
Sure.
Maybe something he wants to work out today, I don't know. So I want to look at it.
Okay.
Thank you. Okay, I'm going to talk to you.
So you have to go downstairs?
No, Your Honor, I finished, but I will remain.
Okay.
To assist Mr. Medina. I have the application of Santos Garcia. May I approach?
Yes, thank you. Ms. Farkas? Oh, do we have, who do we got? You can bring in whoever you want. Okay. Cynthia Browning, this is case number 24 CF 1914. So Ms. Browning, this is your arraignment date, and purpose of today's hearing is just to make a plea, but you do have, as an initial matter, you do have the right to have an attorney. If you cannot afford one, one will be appointed. Do you wish me to appoint the public defender for you?
Yes, please, I should have one already.
Well, this is
Or is this
this is a
separate?
new charge, so
Okay, yes, please.
even if it's the same person, you still gotta have it appointed. So the court's gonna appoint the public defender. I'm gonna go ahead and enter a not guilty plea on your behalf today. That preserves your rights. And then we'll come back on October 16th and let you have, in the interim, you can have a chance to meet with your attorney, okay?
Thank you.
Okay, thank you very much. This is Browning, is that yours, Mr. Medina? Browning?
It's no attorney according to the docket.
I know, I just appointed her.
Yes, Judge, that would be mine, but she does need to do the application.
Yes, okay, thank you. You gotta fill out the application.
Does the state have an offer? Did you?
It's 4 months Okaloosa County Jail.
Okay, so,
But she also lives in Evergreen.
we'll come talk, I'll come talk to you, okay? Unless there's a conflict, Judge, we haven't.
I understand. You always gotta check the contract.
As soon as we can. Be able to see you as soon as I can. Thank you.
Just bring them out whenever they're ready, Steve. Claycomb. Does the state announce?
Yes, Your Honor, this is 24 CF 1966 and 24 CF 1967. This is Ms. Basso's case, Your Honor. I believe she was expecting a plea of not guilty. I believe the state's offer in this is gonna be a lengthy Department of Corrections
Okay,
sentence.
so,
with sex
Mr.
offender.
Claycomb, you do have the right to have an attorney. If you cannot afford one will be appointed. So first order of business, do you wish me to appoint the public defender, or you're gonna hire private counsel?
Yes, sir. Public defender.
Okay, so the court will appoint the public defender. I'm gonna enter a not guilty plea on your behalf on both these cases. That just preserves the status quo, and we'll come back on October 16th at 9 a.m. and we'll give you a chance to meet up with your attorney to look at your options, okay?
This is just your, fill out this application, make sure you sign it. Okay, and give that, and they'll be able to see it for you, so I can get officially appointed. So I'm good with this all, and see what the jail is.
Didn't we do Cone already? Did we do Ms. Farkas Cone?
We did not, I'm ready.
Okay. They'll probably bring him out. Cone?
Julius Cone, 2024 CF 1954. Your Honor, the state and the defense separation agreement, I'm just having Ms. Sharpless and Mr. Cohen sign it.
Okay.
Sign it. Right here. All right, may I approach, Your Honor?
You may.
Sure, I've got all the pieces.
Thank you. Would you announce the terms of the agreement?
Yes, Your Honor. In case 2024 CF 1954, there's one count, possession of a controlled substance. It will be a withhold of adjudication on the one count, 30 days jail as a condition of probation. The 30 days probation will be concurrent to the jail time, and the probation will terminate upon release from jail. So the ending is really 30 days jail, with credit, of course, for time served. $150 public defender fee and 180 days to pay from the date of release.
State?
That's the state's agreement.
Very good. Mr. Cohen, would you raise your right hand? Sir, I just need to ask you a couple questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the agreement, and I see those same terms are written down, you've signed it. So I just want to make sure, have you read the plea agreement closely?
Yes, sir.
Gone over it in detail with your attorney? You
Yes, sir.
understand what you're doing? It's a little bit of a, kind of the way it's worded is a little tricky, but the purpose is to preserve your withhold of adjudication, which is very beneficial. But you have had all your legal questions answered about this?
Yes, sir.
The fact that you're waiving the right to go to a hearing and all that?
Yes, sir.
Okay. You are entering this freely and voluntarily?
Yes, sir.
Based upon that testimony, the court will accept your plea. There'll be a withhold of adjudication, and you're sentenced to 30 days probation. As a condition of that probation, you're also sentenced to 30 days in jail as the condition of the probation, and it'll be concurrent. The probation will be concurrent to the jail time, and the probation will be terminated upon release. $150 public defender fee, 180 days to pay following your release before it gets sent to collections. Okay?
Thank you, Dean.
Hold on.
Hold on.
You have this listed as one count, there's just 3 count. No, that's right.
Oh, how did I? Let me amend it, I will bring it back. Otherwise, it would be a council.
It's possession of
Paraphernalia.
paraphernalia and resisting arrest without violence.
Okay, I'll just add the counts. So,
It'll be the same deal, but they'll all run concurrent.
so I'll make the edits and I can bring it up to the clerk if that's okay.
Yep. So,
Okay, all right.
it's a procedural issue, not a substantive. Okay. Who's this? Gardner.
Should be Thomas Carter before the board,
Gotcha.
24 CF 142. Plea agreement to be filed in Mr. Gardner's case, Your Honor, if I can get him to sign.
Okay.
This is the one that you're talking about.
No, this is the other one. Just confirming with Ms. Sharpless that this was Ms. Jardina's offer.
Okay.
It's gonna
She
be
didn't trust you verbally?
She did, Your Honor, but I tend to be a little bit more cautious.
Okay.
That's my grandfather said, you're born into this world with your name, that's about it, so I'd rather keep my name.
Understand.
Mr. Gardner is going to be entering a plea to a lesser included offense of battery. Mr. Medina.
What's the question? Sorry? Oh, yeah.
It's going to be 784031B.
Thank you.
Give adjudication of guilt, credit for time served, no probation to follow, court costs, PD fee. Mr. Gardner would ask for 24 months from date of release to pay those fees before offset the collections.
State.
That's the state's agreement, Your Honor.
Mr. Gardner, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, I do.
So you heard your attorney state the terms of the plea agreement, and I see those same terms are in the written agreement that you've signed. Just want to make sure you read this closely.
Yes, sir.
Gone over it in detail with your attorney.
Yes, sir.
Had all your legal questions answered?
Yes, sir.
Understand this will be a final resolution, waiving the right to go to a hearing.
Yes, I do.
And you believe it's in your best interest to enter into this plea?
Yes, sir, I do.
And it's free and voluntary, nobody's coerced you to
Yes,
do
sir.
this? Very good. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt to the lesser included charge of battery. The sentence technically is credit for time served, so you can get out. There'll be no probation to follow. $967 in court costs, $150 public defender fee. And you will have 24 months from the time you get out of jail to pay those fees.
Yes, sir.
Or it goes to collections and they'll go after your driver's license.
Yes, Your Honor.
Okay? Anything? Question?
Good.
Good? Thank you. Okay?
Thank you. Sorry about that.
No, you can thank the clerk. She did a good job.
Your Honor, if I could have a second for Mr. King, we had a change in his plea.
Okay.
In Your Honor, part of the conversation with Mr. King is he actually has a parole violation that's the subject of this arrest. We happen to have the officer here. I talked with the officer. There may be a suppression issue associated with that, but it's my understanding that the parole board has already met with Mr. And so he's asked what happens if this goes away, and I've explained to him that my belief is with this, the parole board could still sentence him potentially, even if this does go away, because he was still arrested and had this on him at the time. The state's taken all that consideration and has offered him essentially misdemeanors and time served. So he's been asking, and unfortunately I don't have an answer what the parole board might do. My belief ultimately is if it's reduced, it'll probably look better in the long run. If he wants a dismissal, that's going to take some time, meaning he sits in custody pending all that as well. And so that was kind of the conversation I was having with Mr. King. My belief based upon what his officer said is that he's likely going to be reinstated to community control on the violation.
Your Honor, I made a bad error of judgment on this night in particular. But I want to take care of this. I don't want to go back to prison. I have a job. I obtained my driver's license, a place to stay. I'm a veteran United States Air Force sir, and I just made a bad error of judgment. I just need another chance at life. That's all I need. They've always sent me to prison. Now I'm asking for
What are we doing here today?
In Your Honor, that's the reason the state, what Mr. King has stated is the reason that they're offering misdemeanors and time served.
Okay.
It doesn't affect his license. As I've talked to Mr. King, he got out in March of this year from a 15-year DOC sentence, was able to get a job, a house, and got his license unsuspended. And so part of what I was trying to do is avoid that suspension. The misdemeanor plea accomplishes all of that. And as I said, I just wanted to let him know, that way if he wants to sign it, it's not going to affect your license. You still have your parole violation, but your officer back there is going to make that recommendation. Okay? You good with that?
Yes, sir.
Okay. And I think we've got a plea agreement, Your Honor.
Okay.
Sign that there for me. She's been here all morning, just so you know. You have to thank her because she has been here all morning waiting on you. You know when I told her we did, she didn't have this thing. Hmm? See, that's what you're thinking too, so no more felony. Okay? Hold on to that. And it's a misdemeanor plea, so there'll be no score sheet, Your Honor, if I may approach.
You may. Would you announce the terms of the agreement?
Yes, Your Honor. Mr. King will be entering a plea of no contest for the lesser included offense in count 1 of paraphernalia, which is the same statute cited in count 2 of the information. He'll be adjudicated guilty, sentenced to time served, $270 of court costs, $150 public defender fee. He's entering the plea without the opportunity of review discovery or any of the body cameras in this case, Your Honor. But he would ask for 24 months from the date of release to pay those fees before they're sent to collections.
State?
That's the state's agreement, Your Honor.
Okay. Mr. King, I just need to ask you just a couple questions. Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? So you heard your attorney state the terms of the plea agreement, and I see those terms are laid out in your written agreement that you've signed. So just want to make sure you read this closely and gone over it in detail with your attorney.
Yes, sir.
You understand that by entering, this will be a final resolution of this case? But you are waiving some valuable rights to get here. You're waiving the right to force the state to go to a trial and prove their case and all that.
Yes, sir.
You're putting that aside so you can get a final resolution today. Is that what you want to do?
Yes, sir.
And you believe that's in your best interest?
Yes, sir.
And you're entering this freely and voluntarily?
Yes, sir.
Very good. Based upon all that testimony, the court will accept your plea. There will be an adjudication of guilt on the 2 charges. One is the lesser included, so the 2 possession of paraphernalia charges, which are both misdemeanors. You will, the technical sentence is credit for time served. So you'll be able to get out immediately. There'll be no probation to follow. $270 in court costs, $150 public defender fee. And, you know, you're acknowledging that, you know, there hasn't been, this is very early in the case. You haven't gotten all your discovery, but you still think that's in your best interest. And you will have 24 months from the date of release, which I assume is going to be today, to pay any of these outstanding court costs before they're sent to collections.
Your Honor, I don't know on the release date because it is a parole violation.
Okay.
I just know that.
I don't want to tell you you're getting out immediately and then have some other glitch, but under this case, you're due to get out immediately on this case.
Yes.
Okay? Good luck, sir.
And I think that's all I have for the court today.
All right. Espinol, is that you?
Yes, I have an out-of-custody client who we were gonna address, Sean Seibert,
Okay.
so we can do that one.
Your Honor, for Mr. Barahona Espinal, I'm drafting a trespassing lesser included offense deal that I'm gonna go over with Teresa and see if he wants to take it, if the court can indulge us. It's gonna take me 10 minutes max to get
That's
it.
fine. Well, Mr. Cotton's been standing around here for the last 45 minutes and we're about ready to take his case. He walked out the door. So it'll take a few minutes to get that done.
Yes, sir.
We'll find it.
Your Honor, this is Sean Seibert, 2024 CF 1616. There was a warrant for his arrest for an incident that's alleged quite a few months before this open case. So,
Like one, but yeah, it
Well, I thought it was
happened before.
January.
Yeah, the case that he has open now, Your Honor, happened in February, so this is not a violation of his bond condition term.
So it's, as Ms. Sharpless said, it's not a violation of his bond conditions in this case, and she's agreed to a $10,000 signature bond in the new case. If we can make a note for first appearances tomorrow, if that's possible, as Mr. Seibert could then return to work and keep meeting with me to work on both of these cases. I'm not sure if we can make a note for the first appearance judge in the morning, if the state has already agreed to a bond amount.
Or if the judge could order that today, I don't know if Your Honor can do that today.
Oh, yes, I'm not sure if you could enter that now. That would also, of course, work fine for us.
Yeah, that's what I'm trying to.
Just write it on your warrant paper.
He could be booked, Your Honor, and Your Honor could, if Your Honor was okay, Judge Brown did sign the warrant, but if Your Honor is okay giving him a bond instead of him going to first appearance, the state would stipulate.
I'm fine. And we've got counsel here on both sides that's why we have first appearance. It's not for formality's sake.
Right.
So it's $10,000 cash or professional?
Signature, Your Honor.
Signature. Okay. So ordered.
Okay.
Thank you.
Okay.
So they'll book you, and then you'll sign. I'll talk to you later, okay?
You get that, Madam Clerk?
Yes, Your Honor.
Thank you, Your Honor.
Okay.
That's it.
Okay. Mr. Cotton, sorry.
Good
I
afternoon.
was worried about you. We were about ready to get your case, and then you went out the door.
Can we talk for 2 seconds, Your Honor?
You may.
So,
Now, do we have any other cases? I don't think so.
I
Mr.
don't believe
Gates?
that Mr. Gates
Mr.
or
Ma-
I do.
You're good? Mr. Medina, you're good?
He's got the one that he's.
Oh, you got one, okay. That's right, you're working
I don't
on
have
it.
anything on a specially set docket.
Okay,
I did a week ago, but we resolved it.
right, I heard that. That's good.
I just need to know, so I will obviously leave this one. she's not here today, so I'll let her know.
Yeah, that's okay.
Numbers are
That's
crazy.
fine, but as long as someone
Get
is here that-
some extra.
Yes, that's the only reason is she is a non-affiliate, so to speak, you can say yeah. Hey, Judge, good morning, or afternoon, sorry, it's been one of those already. You're on my client's present.
Okay. What do we need to, where, yeah, where do I need to put it?
You got these for this. Yeah, no problem.
It's 10,000 signature, right?
Yes,
Right.
Your Honor.
Very good. So, let me just say, so you understand, you can pass it on to this, I know this isn't your case, is it?
It is not.
This is a little bit of an unusual case because, you know, I got a request to revoke a bond by the state, but it had already just come from a few days ago, first appearances. There's a reason the judge didn't do that. I had like questions, and it, quite frankly, the motion to revoke wasn't clear about what case it was and what the circumstances were. So I think I have a better idea, but still have some questions. As in, why were these children with this family after the first event? Why wasn't there had the child been removed? You can jump in there.
Your Honor, there's a
First time you come to my
person
court,
from
and I'm here, I'm
Families
putting
First
you on the
Network
spot.
here.
I'm addressing you.
I would call her to testify to answer.
No, we don't need to testify. I'm just, this is an informal hearing.
Your Honor,
Have the
Catherine
children
Burns-
been removed?
Yes, Catherine Burns, I work at Families First Network. So after this incident, the children were removed from the parents' custody and are placed in foster care.
Okay.
So this is the first time that any of these, I am aware of their criminal history, both parents. This is the first one that has been brought to the department's attention for removal.
So you're not telling me when there was an actual 2 charges, child neglect, that the department was not made aware of that through a abuse hotline? Is that what you're telling the
That
court?
is not what I'm insinuating. The department was made aware. This is the first time the department has taken action to remove the children from their parents.
Okay, I won't comment on that. Okay? At least, thank you very much, because I assumed that that was the case, certainly after the third time. Because there was one case that was dismissed, you're aware of that.
I am, Judge.
And then second case, and now this case. All kind of same, some of the same players. Anyway. So, has the state and the defense talked, we're here on the state's motion to revoke.
And yes, Your Honor, that there was some confusion just at Taylor Sharpless for Sarah Bergman on this case, Your Honor. There was some confusion about Ms. Bergman's unavailability to be here today.
That's all right.
So- And I know that Your Honor's JA caught it and said, no, it needs, someone will cover for her.
Yeah,
which I'm
when the
happy-
court
So,
sets a court hearing, the parties can't cancel it.
I understand, Your Honor, and I'll make.
I know it
Ms. Bergman gets that note.
she didn't really, she wasn't trying to do that, but anyway, she may not have.
She wasn't,
Aware
but-
that the court actually made the court hearing and not clerk
Yes,
or
sir.
something like that.
I understood, and I'll.
Anyway, there was a good deal of confusion, that's why I said let's have it, and I tried to do it as quickly as possible, which is why I kind of insisted it be done today and not, next month.
Yes, Your Honor. And I do think we do need to have a bond hearing today. I have reviewed some photos that Mr. Cotton has presented me
Yeah,
with. I do believe that he could present a witness who could testify to their authenticity, Your Honor, and that they would be admissible. So the state doesn't have any objection with those coming in. I do have a note. When we get to it, I have just some argument, Your Honor.
Okay. Is somebody going to explain what these
Yeah, Judge.
photos are?
For the record, Byron Cotton, I'm here with Defendant Jacob Roberson. Your Honor, the photos that have been provided to you are photos that were taken last night, I think. Last night, is my understanding. Those have been verified by Families First Network when they visited the home, that those are the current condition of the home. To have a little background, as I understand this, Judge, you're right. A while ago, there was an original charge. It was ultimately dismissed. It was a supervision issue.
That was in February, right?
Yes, sir.
Okay.
That case was ultimately dismissed. It was a supervision issue. Child got out because the neighbor tore down a fence. They've got, now, Judge, I think it's important to know, we're not just dealing with 4 or 5 normal children. 4 out of the 5 of these children suffer and are autistic and nonverbal. So
I
just
got, no, I'm just saying, I saw that very clearly.
the circumstances are not perfect, and there is difficulty in wrangling. Now, that being said, Judge, there was a charge about a month ago. My client was arrested in June, a few months ago. There was an event. Child got out. He was at home. Yeah. Yeah. So another children got out. One of the children got out while he was on supervision. And he was arrested ultimately for child neglect because there was a child that got out into the street. Ultimately, on this event, that's the violation, and the reason why bond was, my client, there was not a revocation of the bond in this case is because I was at first appearance in this case, and Judge Ward found that my client wasn't even home when this event happened, and he wasn't there supervising on duty. That Danielle Roberson, his wife, was there at the time. My client was at home, I think, playing paintball or something that morning. And believed his wife was handling the children that morning. And he,
Was the wife there?
She was. The wife was there. My client got arrested because he was called back to the house. And when he gets to the house, they arrest him for child neglect. Presumably, maybe the condition of the home is what I can get from the report, but certainly not from he wasn't. She was the one there supervising as the parent, and he was not home. So then obviously there's evidentiary issues with showing when the house became in this condition, if there's feces on the floor, where they were, who's restricted. So all of those things were taken into consideration by Judge Ward in this case to leave that bond in place, set a new bond. There are new conditions. One, as the court's now aware, the children have been removed from the home and are currently in foster care. Now my client's working a case plan, as I understand, and has some visitation with his children to see if that can be rebuilt. In addition, Your Honor, my client, Mr. Roberson is a business owner in this and has been for 9 years, has run his own business, has 6 employees that work with him. He's got both of his parents and actually his ex-wife here in support of him, who are all in support and willing to assist in any way they can, both for the children, for Mr. Roberson, and in any manner they can, that obviously his ability to stay out, work his case, keep his business running, get the house finally repaired, and you can see some of the repairs that have already been made to the home. It is certainly clean or cleaned up, that there's certainly been a lot of repairs. And when this happened, Judge, there was actually, what did they call it when you were in the middle of making repairs on a case plan, is that right?
Right, we were doing construction upstairs.
But that was part of the requirement you were working on?
Yes, correct.
That my client was working on requirements under the DCF case plan he was in from the first case that we're here, that we're here on the bond. So he was working that case.
So was it a court case or a voluntary? Voluntary.
Your Honor, it's my understanding that he was referred for diversion services through wraparound and was working with the wraparound services, so it wasn't even a non-judicial case.
Okay, thank you.
So obviously, I mean, that takes time and money, you know, but things, he was working on that as the father in the household. Now, back to the reason why the bond was not revoked at that time is because at that time, there's evidentiary issues in this second case. My client wasn't even there when this event occurred. And there wasn't another adult in the house that was supposed to be supervising. So based on these conditions, you know, I don't think it's unreasonable, and I would request that the court not violate his bond conditions, or if the court's going to, set him a bond so he can keep his business running, keep in contact with the kids, continue to work his case plans. And I think he is actively participating based on my conversation with Ms. Burns, and jumping through every hoop that's put in front of him to try to do what he's supposed to do.
Well, I think we ought to let the state.
Sure.
See their motion.
So, Your Honor, at a cursory glance of the case, I did log on evidence.com and see if there were pictures. Since Mr. Cotton had given me pictures of the condition of the home now, I looked to see if there were pictures of the scene. The pictures that have been provided to the state attorney's office from the Okaloosa County Sheriff's Office do corroborate that the home was in the deplorable condition that the sheriff's office said it was in at the time. So I understand that the house has been cleaned up now, but at the time, there was an exposed electrical outlet. There does appear to be feces on the wall. There does appear to be either wet or something on the wall. The home appears to be unsafe for children, and there did appear to be medications out for within children's reach. Ms. Berkman wanted the court to know that yes, there was an adult with these children, but she did appear to be under the influence at the time. That is the state's concern. That Mr. Roberson was out on bond for a child neglect, where a child was found by a concerned citizen running the street unsupervised, and now the police have returned to the home, and the home is in deplorable conditions, and the children are not being supervised, and the home is unsafe for children to be there, especially children with issues that need to be supervised. So the state is asking the court to revoke the earlier bond.
Judge, if I could just make two things. One, my client is also voluntarily enrolled and has an appointment tomorrow at Bayer Neurobehavioral Center to enroll also in mental health treatment and counseling. In addition, to address the issues, if we're talking about bond and what's safe, I've provided photos to the court that house is no longer in a case. There's no need to incarcerate my client at this time, given the current state. Two reasons. One, the issues with the house have been cured. Two, the children aren't in the home. So,
how many children are we talking about? They've had several.
There's 5 children. 2, it's my understanding, are currently in a group home in Tampa, which it's my understanding have already escaped from once. And then 2 are in Navarre. He has visitation set with them Thursday. And then 1 is with a grandparent.
And how many of them suffer from autism?
4.
4 of the 5. Okay. Anything further? I'm sorry, I interrupted.
No, Judge. And if the court has questions, frankly, my client would be happy to answer those for the court.
Yes, sir.
So, one of the questions that I have is, what circumstances have changed that would lead this court to override the decision of the first appearance court?
Your Honor, it doesn't appear to the state that Judge Ward understood that the adult that was at the home appeared to be under the influence and not watching the children. So this defendant left the house for a substantial period of time with a person who is...
I don't know that we can go there, Ed. You're giving some good evidentiary information.
That's the state's concern, and that's why the state believes there is evidence of child neglect, Your Honor. So,
Court's not. The question isn't whether the probable cause ruling at first appearance. First appearance did find probable cause, didn't they?
yeah, yes, Your Honor. I do
And
believe he
the
did.
mother, she's also been charged, hasn't she?
And is currently incarcerated, Judge.
And is incarcerated.
Yes, sir. But, and Judge, I think part of that was because the children were directly under her care at the time. She was there. And so my client essentially got called back to the scene and was arrested at that time. And Ms. Roberson, the other defendant, has a separate theft charge also, Judge, that violated bond conditions. Unrelated to any of this stuff at the house. But in response to the court's inquiry, Judge, in fact, the only thing that's changed since first appearance is things have gotten better at the home, based on the information that's been provided, not worse. And there's no danger.
There's what?
There's no danger. The children are no longer in the home and are under the care of other individuals at this time.
Okay. What did Judge Ward do as far as the bond?
He did not, he left the current bond conditions in place that were in place on that.
On
And
the
he
other
said-
one?
On the case that we're here on for the revocation, and he set new bond conditions and my client bond out on the new
He
bond.
said $1,000 in this case, in the new case, Your Honor, and I believe that's 24 CF 2119 to answer the court's question. Judge Ward ordered $1,000 cash or professional on each count, so $1,000.
So there were 5 counts dealing with each
5,000
child.
cash or professional.
Yeah, I mean, unfortunately or unfortunately, Ms. Burns is going to have to deal with me a lot in the coming months. But, so she may not have heard me say this before, but this is actually one of the more complicated areas where these different areas of law collide. And dependency and criminal generally neglect cases, sometimes worse with children, oftentimes present challenging situations because the dependency process is wholly different than the criminal justice system. And the criminal justice system is primarily, by statute, punitive. And dependency is not. It's just the opposite. It's trying to remedy families in order to keep children safe. So I'm glad to hear that the department is involved. Sounds like they're already having some challenges with placement, which goes to some of the challenges. And I mean, clearly there were some, well, it appears that there, based on the allegations, some deficits, there's no question. Basically securing the home and in this individual case, certainly some supervision. The court also recognizes that these are, when you have severe autism, creates some real challenges. And when you have family dynamics that are also problematic and get substance abuse thrown in there, and all of a sudden you've got a cocktail of issues. Court's required to do 2 things on a bond. One is to make sure that, well, is to allow the defendant to have a reasonable bond, and that's usually the easier of the 2 prongs. The other prong is safety to the community, and as a result of that, safety to the community is generally what's invoked when we revoke bonds. When somebody's out on bond and picks up a new law charge. This isn't the reason for that, in my opinion. This kind of circumstance is not the reason. There's some, I see the criminal charges there, but I don't see any new information that was brought to the attention. And I think Judge Ward made a reasoned argument, a reasoned decision. The children are removed, that was my first question. Are the children safe? And the parents are, some of these issues are being addressed, and certainly within the criminal justice system as well as in the dependency system. So Court's going to deny the motion to revoke. Keep the bond as it is in this case. And
Thank you, Your Honor, that's all I have.
the other bonds that are already in place.
Okay. Thank you, Judge. I have nothing else before the court. Thank you for your
very
time.
Thank you, Ms. Burns, for being here.
And we look forward to having you next door.
I sincerely hope you feel that way in 6 months. In the court, I'm going to submit this. Mr. Cotton,
Mr. Thomas, defense
Yes.
exhibit, composite exhibit 1.
That's fine, Your Honor.
Thank you.
Thank you, Judge.
Thank you very much.
Yeah, I can never remember if they're numbers and we're letters, or we're letters and they're not, I can never remember.
I don't know. Ms. Farkas, do you have one more to it?
No, I don't have anything, Your Honor. I was